Please enter the conference number, followed by the pound or hash key. Please hold while I try to connect you.
We're making copies for each of the attorneys and for the interpreters and for each member of the jury.
Your Honor, may I be excused just a moment out of the way?
You may. There's just quite a few copies. Thank you. Okay. All right. Good deal. Thank you. Copy this about ready? Yes, the copy is about ready. Okay, let's go ahead and go on record. This is State of New Mexico versus Alexis Avila. CR 2022-13. It's now about 10:15 on the morning of the 14th of April 2023. We are in open court now, the presence of the jury. Counsel and the court worked yesterday evening and this morning in coming up with jury instructions. The court changed one of them overnight after thinking about it. I've presented to counsel jury instructions that are numbered 1 through 24, and we'll start with those, starting with the state, which you all have a copy of. Are there any objections to any of the proposed jury instructions?
No, sir.
Okay. From the defense, you tendered some other jury instructions. Do you want to make a record on those?
Yeah, briefly, Judge. I tendered 14-2801 in relation to attempted voluntary manslaughter, along with 14-222, which is the definition of sufficient provocation, and then, in addition, 14-140, which is the elements of voluntary manslaughter. My argument was, and still is, that given the litany of sufficient provocation definition, and one including even circumstances that can give rise to, emotions, and it's not an exhaustive list, but terror is even included. I think from all the evidence, including Ms. Avila's recorded statement to police, her testimony, Dr. Cave's testimony, that one could, although the word terror might not be used, I think the jury could surmise or make rational inference that under these circumstances, an emotion like terror, something similar to it, caused sufficient provocation for her to do what she is alleged to have done.
Okay, the court's going to mark as refused defense proposed jury instructions, UGI 14-2801 in regard to voluntary manslaughter, 14-140 in regard to voluntary manslaughter, and 14-22 in regard to sufficient provocation. The court finds that there is no evidence in this case that a reasonable juror could find that provocation requires that it's not sufficient if an ordinary person would have cooled off before acting. The court finds there's nothing in the record that would indicate that there was anything that was sufficient provocation for the acts that are allegedly done by the defendant. So these will be made part of the record for appeal, and the court has marked them as refused. Okay, in terms of the jury instructions, any of the order which they've been placed, any objection from the state?
Your Honor, we're looking at the order. If you go to 11, is referencing first-degree murder.
Yes.
And then 12 references child abuse.
Okay.
Is first-degree murder, but somehow 12
Okay.
in the wrong location.
Yeah, I agree with you. Mr. Conley, do you agree with that?
Yes, sir.
Yeah. I'm going to make okay. What number would you propose to make as number 11?
So it should be the one that says, you've been instructed on the crime of child abuse.
Okay, which is presently 14.
Yes.
Okay, 14 will now become 11.
Right.
Any objection, Mr. Conlon?
No, sir. It's fine.
And then 13 and 16 need to be switched.
Hang on just a minute. I'm really- Okay. 16 becomes 13.
Yes. No, 13 and 16 is the swap.
Okay. All right, what is your proposal on what becomes 14 and 15?
Is correct, it's great bodily harm.
Is what? I'm sorry.
14 and 15 are all their child abuse.
Okay. 15 originally was about child abuse. Are you saying it should come when? Right now we have 13 being the child abuse, great bodily harm, and then without great bodily harm, the 4 possible verdicts. And then you're saying, what comes next? How do you want it next? Mr. Conlon,
That's fine with me.
what's fine with you?
Well, I guess you were asking, I think I barely got you there. You were asking me the order. And
Yeah.
I was kind of leaving it up to them because
Okay, well,
I'm not real picky about it.
6,000.
I mean, they're out of order. Clearly, they're trying to fix it.
Okay, Your Honor, I think the problem is, I may just not be seeing it. I'm not seeing 6002B. The one, you do 6002A, you've been instructed on the crime side. Then you go through, you must consider, and then you go to the lesser, and you go to the lesser. I don't see 6000, that's why I'm confused. I'm quickly trying to see, find it.
okay, how does 6002B start?
It's the one that says, how do you consider the crime? The second fairly, so
I know that, and they were all in different order.
right.
6002B is to aid you in your deliberations, it starts out, which is 12 as regard to child abuse.
Yes.
Okay.
All right, is that what you were looking for?
Yes.
And you want that to be
So you got
14?
No, it should stay 12 if you switched out 11. For
Okay.
14.
All right,
11 for 14. Then you go 12, 13. Should be 16.
I agree with that.
You switch those.
all right.
And then 14 stays.
Got childish too, saying you find not guilty.
And then you have,
What was 13?
which one
Which is first degree murder, step down.
on first degree? Okay, so it's to aid in your deliberations on the attempt to commit first degree. That's the one I'm on. Does the court have that one?
No.
Okay. So that's what we're missing.
I know you got it. I know it was.
Well, I mean, yeah, it's just a lot of paper. I'm just saying it's,
Yeah, no, I just, it's somewhere. So there's
Okay. This is on first degree, second degree, right?
yes.
Okay. Copy this off. I have it now. I didn't have it on my loose copy. That'll be, you have it.
Yeah, that's the defense's copy. It's got the instruction number. If you'll just look at it and make sure it's first and second.
It is. We'll need copies for everyone though. And this will be number 17. 17.
Give us 1 second.
I'll try to figure it out, good.
I think it should be 15, Your Honor, but let me double check that.
15.
Oh, 16.
So 16.
16. And then
Yeah,
the
four
fourth, I
possible
agree.
verdicts
Yeah, I
will
see
be
it
the next
now.
one. Okay.
Okay. This will be 16. And then the four possible verdicts in this case will be 17. And then we'll get into the stock, judges of credibility, all those go up one number. Actually, what I'm going
I mean,
to
the
make
numbers
them,
would be wrong, but
I'm going to make you alone or judges of credibility 17A, and then the numbers will track for the rest. So we just need, I need to make that 17. Okay, we'll make copies of that, and as I understand it, Mr. Combo, you're in agreement with the order at this time?
Yes, sir, that's fine.
was previously 11 needs to go in there somewhere too. Which is, you have been instructed on the crimes of first and second degree attempt.
Yeah, that's 6002A, so those are for B.
Right.
And, yeah,
So what number do we need to put that?
I think that's going to turn into.
Okay, well, we were at 15, we started with 16 on that A drive, and we did 17 for the verdict, so I guess 16A, or you just remember?
I'm renumbering.
Okay, so then I guess it would have been, when you get the 6002A for first degree on there, it would have been the 16. 6002B would have been 17. Full cost of the budget.
I'm gonna wait till she gets back.
Yeah, well, yeah, once you have them all in place, yeah.
Yeah.
Otherwise, it's just confusing.
Yeah, it's too confusing.
Yeah, these new instructions are a lot.
The step downs are pretty hard to put together sometimes.
Yeah. Fun to write, I'd say that.
Is there any other matter that we need to take up after we get the jury instructions in order?
No, not from the facts.
Okay.
So you can take your statement out, and you're going to try to put it in order. She took care of it.
Okay, the instruction that starts out, you have been instructed on the crimes of attempt to commit the crime of first degree murder and second degree murder. I believe at this point that ought to be, I'm gonna make it 15A.
Okay.
And then 16 is to age in your deliberation. And then 17 is forms of verdict in the case are verdict, we find the defendant not guilty of attempt to commit first degree murder. Verdict, guilty, attempt to commit first degree murder. Not guilty, attempt to commit second degree murder. Guilty, second degree murder. Not guilty, abuse of a child resulting in great bodily harm. Guilty, abuse of a child resulting in great bodily harm. Not guilty, abuse of a child, and guilty. Okay, are we ready for the jury?
Believe so, Judge.
Stay ready.
Yes. And we just want to make sure we'll like turn the phone for us before we
Yes.
close.
Why don't you go ahead and do that now, so we don't have to do it when. Yeah.
You do.
putting them in order for the interpreter. Do we have a jury instruction 14 at this point?
That's what we were trying to figure out. We put 11 and 14 were to get swapped, so 14 went to 11, 11 went to 14.
What is it? That should be 14. Okay, jury ready?
Your Honor, does the interpreter have the right order?
Yes, she did.
Okay, thank you.
She's bringing,
Yeah,
she's bringing it to.
Very well.
and Your Honor, the state will be using PowerPoint for closing, just so
That's
you're
fine.
aware when it gets
I just put it down so that you see.
Yes, sir.
Please stand for the jury. You may be seated. Good morning.
Good morning.
I want to apologize for the delay. It took longer than what we anticipated. Ladies and gentlemen, you've heard all the evidence in the case. It's now my duty to instruct you on the law that you must follow in deciding the case. The law governing this case is contained in instructions that I am about to give you. It is your duty to follow the law as contained in these instructions. You must consider these instructions as a whole. You must not pick out one instruction or parts of an instruction and disregard others. A copy of these instructions will be given to you when you begin your deliberations. The law presumes the defendant to be innocent unless and until you are satisfied beyond a reasonable doubt of her guilt. The burden is always on the state to prove guilt beyond a reasonable doubt. It is not required that the state prove guilt beyond all possible doubt. The test is one of reasonable doubt. A reasonable doubt is a doubt based upon reason and common sense, the kind of doubt that would make a reasonable person hesitate to act in the graver and more important affairs of life. For you to find Alexis Nicole Avila guilty of child abuse resulting in great bodily harm, as charged in count 1, the state must prove to your satisfaction, beyond a reasonable doubt, each of the following elements of the crime. 1. Alexis Nicole Avila threw baby boy into a dumpster. 2. By engaging in the conduct described in paragraph 1, Alexis Nicole Avila caused or permitted baby boy to be placed in a situation that endangered the life or health of baby boy, or to be exposed to inclement weather. 3. Alexis Nicole Avila showed a reckless disregard for the safety or health of baby boy. To find that Alexis Nicole Avila showed a reckless disregard, you must find that Alexis Nicole Avila's conduct was more than merely negligent or careless. Rather, you must find that Alexis Nicole Avila caused a substantial and unjustifiable risk of serious harm to the safety or health of baby boy. A substantial and unjustifiable risk is one that any law-abiding person would recognize under similar circumstances, and that would cause any law-abiding person to behave differently than Alexis Nicole Avila, out of concern for the safety or health of baby boy. 4. Alexis Nicole Avila's conduct resulted in great bodily harm to baby boy. 5. Baby boy was under the age of 18. 6. This happened in New Mexico on or about the 7th day of January, 2022. Great bodily harm means an injury to a person which creates a high probability of death or results in loss of any member or organ of the body, or results in permanent or prolonged impairment of the use of any member or organ of the body. For you to find Alexis Nicole Avila guilty of child abuse as charged as a lesser included offense in count 1, the state must prove to your satisfaction, beyond a reasonable doubt, each of the following elements of the crime. 1. Alexis Nicole Avila threw baby boy into a dumpster. 2. By engaging in the conduct described in paragraph 1, Alexis Nicole Avila caused or permitted baby boy to be placed in a situation that endangered the life or health of baby boy. 3. Alexis Nicole Avila showed a reckless disregard without justification for the safety or health of baby boy. To find that Alexis Nicole Avila showed a reckless disregard, you must find that Alexis Nicole Avila's conduct was more than merely negligent or careless. Rather, you must find that Alexis Nicole Avila caused a substantial and unjustifiable risk of serious harm to the safety or health of baby boy. A substantial and unjustifiable risk is one that any law-abiding person would recognize under similar circumstances, and that would cause any law-abiding person to behave differently than Alexis Nicole Avila out of concern for the safety or health of baby boy. 4. Baby boy was under the age of 18. 5. This happened in New Mexico on or about the 7th day of January, 2022. In addition to the other elements of child abuse resulting in great bodily harm and child abuse, the state must prove to your satisfaction, beyond a reasonable doubt, that the defendant acted intentionally when she committed the crime. A person acts intentionally when she purposely does an act which the law declares to be a crime. Whether the defendant acted intentionally may be inferred from all the surrounding circumstances, such as the manner in which she acts, the means used, and her conduct, and any statements made by her. For you to find the defendant guilty of an attempt to commit the crime of first-degree murder, willful and deliberate, as charged in count 1, the state must prove to your satisfaction, beyond a reasonable doubt, each of the following elements of the crime. 1. The defendant intended to commit the crime of first-degree murder, willful and deliberate. 2. The defendant began to do an act which constituted a substantial part of the first-degree murder, but failed to commit the first-degree murder. 3. This happened in New Mexico on or about the 7th day of January, 2022. In addition to the other elements of attempt to commit first-degree murder, willful and deliberate, you must consider whether defendant's acts related to the commission of first-degree murder, willful and deliberate. The defendant is not charged with first-degree murder, willful and deliberate. However, the law declares that to be a crime when 1. The defendant killed baby boy. 2. The killing was with the deliberate intention to take away the life of baby boy. 3. This happened in New Mexico on or about the 7th day of January, 2022. For you to find the defendant guilty of attempt to commit the crime of second-degree murder, as charged as a lesser included offense in alternate count 1, the state must prove to your satisfaction, beyond a reasonable doubt, each of the following elements of the crime. 1. The defendant intended to commit the crime of second-degree murder. 2. The defendant began to do an act which constituted a substantial part of the second-degree murder, but failed to commit the second-degree murder. 3. This happened in New Mexico on or about the 7th day of January, 2022. In addition to the other elements of attempt to commit second-degree murder, you must consider whether the defendant's acts related to the commission of second-degree murder. The defendant is not charged with second-degree murder. However, the law declares that to be a crime when 1. The defendant killed baby boy. 2. The defendant knew that her acts created a strong probability of death or great bodily harm to baby boy. And 3. This happened in New Mexico on or about the 7th day of January, 2022. You have been instructed on the crimes of child abuse resulting in great bodily harm and child abuse as charged in count 1. It is for you, the jury, to choose the manner and order in which you deliberate on the crimes charged in count 1. However, to return a verdict, you must follow the procedures described in the next instruction. To aid you in your deliberations and in returning your verdict, you will be provided both guilty and not guilty verdict forms for each of the crimes charged in count 1. Unless you unanimously agree on a verdict, you should not sign a verdict form for that crime. Although you may deliberate on the crimes charged in count 1 in any manner and order which you choose, you must return your verdict for each offense in count 1 in the order they are instructed. Under this procedure, if you unanimously find the defendant guilty of child abuse resulting in great bodily harm, you should sign the guilty verdict for that offense, and you should not proceed to reach a verdict on the remaining offense. If, after reasonable deliberation, you did not reach a unanimous verdict on child abuse resulting in great bodily harm, you should not sign a verdict form for that offense, and you should not proceed to reach a verdict on the remaining offense. You should only return a verdict on child abuse if you unanimously find the defendant not guilty of child abuse resulting in great bodily harm. If you unanimously find the defendant not guilty of child abuse resulting in great bodily harm, you must sign the not guilty verdict form for child abuse resulting in great bodily harm before returning a verdict on any other crime charged in count 1. If you unanimously find the defendant guilty of child abuse, you should sign the guilty verdict for that offense. If you do not reach a unanimous verdict on child abuse, you should not sign a verdict form for that offense. If you unanimously find the defendant not guilty of child abuse, you must sign the not guilty verdict form for child abuse. If you unanimously find the defendant not guilty of child abuse resulting in great bodily harm, you may then return a verdict on child abuse. If you do not reach a unanimous verdict on child abuse, you should sign the corresponding verdict form for that offense. If you are not unanimous on a verdict, do not sign a verdict form for that offense. In this case, as to the charge of child abuse resulting in great bodily harm contained in count 1, there are 4 possible verdicts as to the defendant, Alexis Avila. 1. Guilty of child abuse resulting in great bodily harm. 2. Not guilty of child abuse resulting in great bodily harm. 3. Guilty of child abuse. 4. Not guilty of child abuse. You must consider each of these crimes. You should be sure that you fully understand the elements of each crime before you deliberate further. You have the discretion to choose the manner and order in which you deliberate on count 1, but you must return a verdict of not guilty on child abuse resulting in great bodily harm before entering a verdict on child abuse. You will then decide whether the defendant is guilty of the crime of child abuse resulting in You will first decide whether the defendant is guilty of the crime of child abuse resulting in great bodily harm. If you unanimously find the defendant guilty of child abuse resulting in great bodily harm, then that is the only form of verdict which is to be signed as to this count. If you unanimously find the defendant not guilty of child abuse resulting in great bodily harm, then you should sign only the not guilty form as to child abuse resulting in great bodily harm. If, after reasonable deliberation, you do not reach a unanimous verdict on child abuse resulting in great bodily harm, you should not sign a verdict form for that crime, and you should not proceed to reach a verdict on the remaining crime. If you unanimously find the defendant not guilty of child abuse resulting in great bodily harm, you will then go on to consideration of the crime child abuse. If you unanimously find the defendant guilty of child abuse, then that is the only form of verdict which should be signed. But if you unanimously find the defendant not guilty of the crime of child abuse, then you should sign only the not guilty form. If, after reasonable deliberation, you do not reach a unanimous verdict on child abuse, you should not sign a verdict form for that crime. You may find the defendant guilty. You may not find the defendant guilty of more than one of the foregoing crimes. If you have a reasonable doubt as to whether the defendant has committed any one of the crimes, you must determine that the defendant is not guilty of that crime. If you find the defendant not guilty of all of these crimes, in count one, you must return a verdict of not guilty as to this count. You have been instructed on the crimes of attempt to commit the crime of first-degree murder, willful and deliberate, and attempt to commit the crime of second-degree murder, as charged in alternate count one. It is up to you, the jury, to choose the manner and order in which you deliberate on the crimes charged in alternate count one. However, to return a verdict, you must follow the procedure described in the next instruction. If you unanimously find the defendant not guilty I've got one that seems to be out of order. Council Martin Approach. This is clear out. Great.
Yes, sir.
I apologize for the interruption and the quite a few instructions. To aid you in your deliberations and in returning your verdict, you will be provided both guilty and not guilty verdict forms for each of the crimes charged in alternate count one. Unless you unanimously agree on a verdict, you should not sign a verdict form for that crime. Although you may deliberate on the crimes charged in alternate count one in any manner and order which you choose, you must return your verdicts for each offense in alternate count one in the order they are instructed. Under this procedure, if you unanimously find the defendant guilty of attempt to commit the crime of first-degree murder, willful and deliberate, you should sign the guilty verdict for that offense and should not proceed to reach a verdict on the remaining offense. If, after reasonable deliberation, you do not reach a unanimous verdict on attempt to commit the crime of first-degree murder, willful and deliberate, you should not sign a verdict form for that offense, and you should not proceed to reach a verdict on the remaining offenses. You should only return a verdict on attempt to commit the crime of second-degree murder if you have unanimously find the defendant not guilty of attempt to commit the crime of first-degree murder, willful and deliberate. If you unanimously find the defendant not guilty of attempt to commit the crime of first-degree murder, willful and deliberate. You must sign the not guilty verdict form for attempt to commit the crime of first-degree murder, willful and deliberate, before returning a verdict on any other crime charged in alternate count 1. If you unanimously find the defendant guilty of attempt to commit the crime of second-degree murder, you should sign the guilty verdict for that offense. If you do not reach a unanimous verdict on attempt to commit the crime of second-degree murder, you should not sign a verdict form for that offense. If you unanimously find the defendant not guilty of attempt to commit the crime of first-degree murder, willful and deliberate, you may then return a verdict on attempt to commit the crime of second-degree murder. If you do not reach a unanimous verdict on attempt to commit the crime of second-degree murder, you should sign the corresponding verdict form for that offense. If you are not unanimous on a verdict, do not sign a verdict form for that offense. In this case, as to the charge of attempt to commit the crime of first-degree murder, willful and deliberate, contained in alternate count 1, there are 4 possible verdicts as to the defendant, Alexis Avila. 1. Guilty of attempt to commit the crime of first-degree murder, willful and deliberate. 2. Not guilty of attempt to commit the crime of first-degree murder, willful and deliberate. 3. Guilty of attempt to commit the crime of second-degree murder. 4. Not guilty of attempt to commit the crime of second-degree murder. You must consider each of these crimes. You should be sure that you fully understand the elements of each crime before you further deliberate. You have the discretion to choose the manner and order in which you deliberate on this count. But you must return a unanimous verdict of not guilty on attempt to commit the crime of first-degree murder, willful and deliberate, before ending a verdict on attempt to commit the crime of second-degree murder. You will first decide whether the defendant is guilty of the crime of attempt to commit the crime of first-degree murder, willful and deliberate. If you unanimously find the defendant guilty of attempt to commit the crime of first-degree murder, willful and deliberate, then that is the only form of verdict which is to be signed as to this count. If you unanimously find the defendant not guilty of attempt to commit the crime of first-degree murder, willful and deliberate, then you should sign only the not guilty form as to attempt to commit the crime of first-degree murder, willful and deliberate. If, after reasonable deliberation, you do not reach a unanimous verdict on attempt to commit the crime of first-degree murder, willful and deliberate, you should not sign a verdict form for that crime, and you should not proceed to reach a verdict on the remaining crimes. If you unanimously find the defendant not guilty of attempt to commit the crime of first-degree murder, willful and deliberate, you will then go on to consideration of the crime of attempt to commit the crime of second-degree murder. If you unanimously find the defendant guilty of attempt to commit the crime of second-degree murder, then that is the only form of verdict which should be signed. But if you unanimously find the defendant not guilty of the crime of attempt to commit the crime of second-degree murder, then you should sign only the not guilty form. If, after reasonable deliberation, you do not reach a unanimous verdict on attempt to commit the crime of second-degree murder, you should not sign a verdict form for that crime. You may not find the defendant guilty of more than one of the foregoing crimes. If you have a reasonable doubt as to whether the defendant has committed any one of these crimes, you must determine that the defendant is not guilty of that crime. If you find the defendant not guilty of all of these crimes in alternate count 1, you must return a verdict of not guilty as to this count. You alone are the judges of the credibility of the witnesses and the weight to be given to the testimony of each of them. In determining the credit to be given any witness, you should take into account the witness's truthfulness or untruthfulness, ability and opportunity to observe, manner while testifying, any interest, bias, or prejudice the witness may have, and the reasonableness of the witness's testimony, considered in the light of all the evidence in the case. You are the sole judges of the facts in this case. It is your duty to determine the facts from the evidence produced here in court. Your verdict should not be based on speculation, guess, or conjecture. Neither sympathy nor prejudice should influence your verdict. You are to apply the law as stated in these instructions to the facts as you find them, and in this way decide the case. An expert witness is a person who by knowledge, skill, experience, training, or education has become expert in any subject. An expert witness may be permitted to state an opinion as to that subject. You should consider each expert opinion and the reasons stated for the opinion, giving them such weight as you think they deserve. You may reject an opinion entirely if you conclude that it is unsound. Before you consider a statement made by the defendant for any purpose, you must determine that the statement was given voluntarily. In determining whether a statement was voluntarily given, you should consider if it was freely made and not induced by promise or threat. In determining whether the statement was induced by promise or threat, you may consider the defendant's mental state. Each crime charged in the information should be considered separately. Your verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agrees. Your verdict must be unanimous. It is your duty to consult with one another and to try to reach an agreement. However, you are not required to give up your individual judgment. Each of you must decide the case for yourself, but you must do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own view and change your opinion if you are convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of evidence solely because of the opinion of your fellow jurors or for the purpose of reaching a verdict. You are the judges of the facts. Your sole interest is to ascertain the truth from the evidence in the case. You must not concern yourself with the consequences of your verdict. Verdict forms have been prepared, and as to each count, there's a verdict. So there's the verdict forms. Here they are. The verdicts are as follows. We find the defendant, Alexis Nicole Avila, not guilty of attempt to commit first-degree murder as charged in count 1. Or, verdict. We find the defendant, Alexis Nicole Avila, guilty of attempt to commit first-degree murder as charged in count 1. Verdict. We find the defendant, Alexis Nicole Avila, not guilty of attempt to commit second-degree murder as charged in count 1. Verdict, we find the defendant, Alexis Nicole Avila, guilty of attempt to commit second-degree murder as charged in count 1. Verdict, we find the defendant, Alexis Nicole Avila, not guilty of abuse of a child resulting in great bodily harm as charged in count 1. Verdict, we find the defendant, Alexis Nicole Avila, guilty of abuse of a child resulting in great bodily harm, is charged in count 1. Verdict, we find the defendant, Alexis Nicole Avila, not guilty of abuse of a child, is charged in count 1. Or verdict, we find the defendant, Alexis Nicole Avila, guilty of abuse of a child, is charged in count 1. Now the lawyers will argue the case. What is said in the arguments is not evidence. It is an opportunity for the lawyers to discuss the evidence and the law as I have instructed you. The state will argue first, the defense will then argue, the state may then reply. Ms. Lutz?
Waiting for approval on the screen. May it please the court,
You may proceed.
counsel. Ladies and gentlemen of the jury, when we started this trial, we talked about a lot of things. So let's talk about what we now know. We know this case is all about choices. The choices made by Alexis Nicole Avila. The defendant was supposed to care and protect her baby boy. But instead, the choices she made that followed were to try to end the life of that newborn and get away with it. She gave birth at home alone. She cut that umbilical cord in some manner. She wrapped that baby boy in a towel and left him lying on the bathroom floor while she focused on cleaning. Then she decided to get a plastic bag and put the baby in basically a shopping bag. She then carried that bag out to her car. And we know that a picture is worth 1,000 words. A picture is worth 1,000 words. We've seen this video. Let's watch it again, January 7th, 2022 at 2 o'clock in the afternoon. Sorry, ladies and gentlemen, you know me and the technology's been like that all week. Here we go. We know that Alexis Avila drove around to find the right location. She ended up behind the mall at the dumpsters belonging to Rig Outfitters. We know that it was a cold January day. Right now, at the time, around 2 o'clock when she was pulling up, the sun is out, probably a little bit warmer. And we see her retrieve that bag from the back seat and toss it into that dumpster, that giant metal dumpster, and just drive away. Now, during the trial, you saw the other video. The video where she continued to drive down that alley, down the back, away from the mall, and in turn, and you didn't see her car again. You didn't see her brake and back up. You didn't see her brake and turn around. You didn't see her circle the block and come back and decide to undo that decision. No. What you know what followed was that she went home. She went home, leaving this baby boy inside of that bag. Inside of that bag, inside of that cold metal dumpster. The black bag, 2 of them, remember, and a white bag, and trash. This is the bag that she left that baby boy inside of and just drove away. The bag that had been in the dumpster contained that young newborn, hours old. But thankfully, there were good Samaritans that came along around 7 in the evening and decided to stop and start going through the dumpsters. April Nuttall, Hector Hasso, Michael Green. They started hearing sounds. You heard them. They heard sounds. And so they're digging. And Michael's standing up on the side, and he's tossing stuff into the other dumpster. And they pulled that bag out, and they set it on the ground. And it's moving. You heard them say, it's moving. And so they were a little bit, probably freaked out, right? This bag moving on the ground. They're hearing some sounds, right? But it was April Nuttall who was like, opening up that bag, right? You heard her. She opened up that bag. You saw that video. She opened up that bag and saw that baby inside. And then you saw their reactions. They're shocked. They're surprised. They can't believe this baby is in a trash dumpster. And April picks up that baby. She picks up that baby and she pulls it to her. She knows it's got to get warm. It's got to get warm, it's cold, and she puts it inside of her jacket, gets inside that pickup, and is getting that baby warm. The trash and that bag were collected, and that's what's in State's Exhibit. That's what Alexis Nicole Avila put that baby in. They know from that video, they got that partial plate to try to be able to figure out who that was that left the baby in the dumpster. Because what we know is if it had not been for those 3 individuals, the police that showed up, and you heard from Jennifer Maxwell, she said nobody told her, hey, check on the baby on the radio, or directed her over to the baby. She knew there was a baby, and she just went to get it. And then she just took it to the ambulance when they arrived and gave it to EMS. And EMS was gone. You saw that, gone in seconds. We saw that from Officer Biddick's body-worn camera. Everybody reacting immediately to a newborn needing to be cared for, needing to be protected. Everybody. But Alexis Avila. Over 6 hours, that baby had been in the cold, near freezing temperature, in that dumpster. Now, what did Alexis Avila know at that time? She knew that she was pregnant. Now, how do we know that? Well, let's think about what you know now. Well, we know that she says she took a pregnancy test, not one but two, in August of 2022. We know that she, on January 6th, after going to the clinic a couple days before, had a pregnancy test taken. Different clinic. She went to Norley and then went to Hobbs same day clinic on the 6th. And they tell her she's pregnant. They tell her that she's pregnant. But we also now know, you heard from Stephen Astorga. He told you that Alexis contacted him, came to where he was, showed him a positive test in April of 2022. She knew she was pregnant. So let's talk a little bit about what all went on. You heard from a lot of experts, right? You heard from a lot of experts. Let's start with Dr. Hammock, the ER doctor. This baby boy had a low heart rate, right? Almost half what should have been, because he was so cold, dehydrated, undernourished, left, newborn, nothing, just thrown in that sack. Profound hypothermia. Remember, there was mild, moderate, severe, profound. It's at the top of the chart for how cold he was. It couldn't even register a temperature for this child. That's how cold he was. You heard that babies can't regulate their temperature the same way. And certainly a newborn left on his own in a bag in a cold metal dumpster on a January night. He was listless. Remember, not moving. Floppy, as some described it. Low tone. What did Dr. Hunnick and the staff at the ER at the Hobbs Hospital immediately do? Warm blankets, a lot. Warm IV fluids. They even tried to warm up the oxygen. Anything to try to bring this child's body temp up so that the blood could flow again. Blood flow. Oh, I didn't even talk about the unclamped umbilical cord left open for blood to come out. Why is it that we don't know how much blood came out of that umbilical cord? Well, let's start. Because he was left on the bathroom floor, and then he was put in a white bag, and then he was put in a black bag, and then he's just left laying in that cold dumpster for 6 hours. No way to try to figure out. But what they did know was how low his red blood cell count was, how low his heart rate was, his blood pressure. That they could determine. So let's now go to the flat staff. We have the flat crew who is, remember they had a flat crew come from Lubbock because this little newborn come to Hobbs to get the baby, to take the baby back, and then Dr. Drennan, the NICU doctor. Man, she jumped in and she got to work for baby boy. She got him a blood transfusion. Remember how low that blood cell count was? 26, should have been 45. Remember the concern about those kidneys? Remember, the kidneys was a huge concern all the way through. And the creatinine was at 1.6. I mean, it was like the top of the chart for concern, and they kept checking that. Remember? That's something they kept watching. They're trying to get him to breathe. They're trying to get him warmed up. They're trying to get fluids into him so fluids can come out. You know, are those kidneys going to work properly? Amazing number of staff at the ER at Covenant Children's Hospital took over the care for that child and then admitted him into the NICU. There, he had a team of doctors. Didn't just have Dr. Drennan, then he had Dr. Bowman and Dr. Kumar. 3 of the 4 neonatologists took care of baby boy. But it didn't stop there. They continued to care for him for days to get him back to where he was on the road to being well. Yeah, they stabilized him really quickly because of the fast work of all these people. You can sit down and up. April, Hector, Michael, the officers, the EMS, the crew at the ER, the flat crew. And then you get to Covenant in ER. And then you get to the NICU. Think of the number of people that did amazing work in the first 24 hours of this child's life to save his life and stabilize him. All because of in a few short minutes or maybe a few short hours, the actions of Alexis Nicole Avila. All of that to undo what she had done. She had been advised on the 6th that she was having labor contractions to go to the ER. Where'd she go? Where did she go? Let's think about that. Let's think. Did she go to the ER? She didn't go to the ER. No. Where'd she go? Oh, she went to work. She went to work. Oh, and then she went to dinner with her family. Remember? Because they, it's just a weekly meal. They had dinner. And then she went home. She didn't go to school that week, that whole week. Stayed at home. Stayed at home in bed, up trying to go to the bathroom, up trying to go to the bathroom. Didn't tell her parents, didn't tell her friends, didn't tell anybody. Clinic had told her she was pregnant and that she was in labor. And yet, she sat on the stand and would tell you all that she was shocked or couldn't remember. Couldn't remember. Oh, that's right, blackouts. That's right, blackouts. We didn't hear about blackouts in the interview with Detective Perez. We didn't hear that word. But we sure heard it a lot yesterday. Instead, what we heard with Detective Perez was that, well, she was young. She's barely 18, and she didn't know what to do, and so she panicked, and so, obviously she panicked, and so, everyone would get a shopping bag and throw a baby into it and then drive to a dumpster and toss it in there. I mean, right, that's what panic would be, right? No. A reasonable person would have called somebody, would have called anybody, called a friend, called 911. Called that clinic she went to. She had a phone. We know that. She knew she was in labor. So all that, I just thought I was constipated, just thought I was constipated, just thought I was constipated. She knew she was in labor. And remember those text messages? How she wanted to brush that off as, maybe that was sarcasm. She's being asked by people if she was pregnant because she now had the test that Stephen knew about, the test she took on that TikTok challenge that were positive. And so, wonder why we don't have to wonder. We know why people thought she was pregnant. Because it's out there, remember? Stephen said he even told a friend. And Alexis said she did that test with not friends, she called them acquaintances. So even somebody even more far removed from her personal circle of people she would trust she tells about a positive pregnancy test. Well, let's talk about why the defendant is guilty of attempted first-degree murder. I'm going to work backwards from the way you're instructed. Attempted first-degree murder, you have to, there are two instructions, so it's kind of confusing. But basically, it's just you're finding that she attempted to commit a substantial portion of the first-degree murder that's defined. That she intended to take the life of a baby boy, and that it was done on the day, January 7, 2022, in New Mexico. But it's not completed because the child lived. Ladies and gentlemen, I submit to you, she is guilty, and the state has met its burden beyond a reasonable doubt to attempt to commit first-degree murder. Now, you have a lesser included on second degree, and let's talk a little bit about the difference between the attempt to commit second and attempt to commit first. Attempt to commit second is just that you believe there's a strong probability of your actions that could result in death. Well, okay, let's talk about that. Alexis Avila has a child at home, and she wraps the child up and leaves him in the towel on the floor, right? Okay. So, just leaving that child in a towel on the floor and doing nothing. Strong probability of death, right? No food, no care, no nothing, just laying there. But inside of a house, maybe the temperature's better, right? But strong probability of death. Okay. Put inside of one bag, right? One bag. Okay. That white bag. Had the little handles on it. Put inside the white bag. Okay, so we go just a little bit further. Then carried out to the car and put inside a black bag, right? Not one black bag, but two black bags. Okay, put in the floor of the car. Well, then take a hair tie and tie that hair tie around the top so that, you know, it's trash. You usually tie up a trash bag, right? You're going to close it. Tie it up, okay, in the car. All right, car's probably warm. Just drive in the car. Okay, strong probability of death. Okay. But once she took that bag out of her car and she stood at that metal dumpster and she tossed that bag into the air, that baby boy, like it was nothing more than trash. Ladies and gentlemen, that's the intent. That's what she crossed over, the intent to take the life of that child as he landed in that metal dumpster, and she got in her car and she drove away. Now let's talk about child abuse resulting in great bodily harm. GBH, as we call it. Well, that's a long instruction. When you get a copy of it, you'll understand why it took so long to get through these. It's a lot. So first, the state is required to establish each element beyond a reasonable doubt. The first one, Alexis Avila threw baby boy into a dumpster. You had that on video. She engaged in the conduct that caused a permitted baby boy to be placed in a situation that endangered the life or health of baby boy or exposed to inclement weather. Well, we know that by driving away and leaving that baby in that big metal dumpster on that cold January day, where trash was going to be put in that dumpster, who knows what could have been put in on top of him? Who knows if somebody would have found him? And so the fact that he was left there by her at that time in the freezing cold, sealed in plastic, tossed in garbage, exposed umbilical cord, risk of sepsis. Alexis Avila showed a reckless disregard for the safety of baby boy. But to find that she had this reckless disregard, you have to go even further. And you have to determine that it caused a substantial and unjustifiable risk of serious harm to the safety of baby boy. And so from that, there is nothing justifiable about the actions of putting this baby in a bag and throwing him in the dumpster. There is nothing justifiable about that. Great bodily harm. Now that's the difference between the two instructions on child abuse that you have. You just have that one little paragraph out of the second one that doesn't say resulted in great bodily harm. So both of those instructions, you'll be able to look at them and compare the differences that one paragraph. The state submits to you that we have proven beyond a reasonable doubt that there is great bodily harm. And let's talk about great bodily harm. We know from Dr. Nino, what did she tell you? She was the child abuse expert that talked about what this meant. And she said the injury to this child, that profound hypothermia, the bradycardia, the kidney damage, the umbilical cord open, all of those things would have resulted in the inevitable death of baby boy had he had been left in that dumpster and not found. But he had the injury to his kidneys, low heart rate, the profound hypothermia, they had to do the oxygen. All of those are injury. And so the definition of great bodily harm is either the definition of a possibility of death or of the prolonged injury to the organs. And so you have that separate definition of great bodily harm. We know the age of the baby. We know he was hours old, basically a day old when this happened. And it happened in New Mexico on January 7th. We know that this really all comes down to the choices of Alexis Avila. The choices that she made to throw that baby in the dumpster and drive away. She made the choice not to go back. She made the choice not to tell anyone. She made the choice not to call anyone. She went home to her room, to her bed, with everything all cleaned up, those towels crumpled in the floor by the closet door. Parents came home, didn't say anything to anybody. Life is just going on until the police come. Ladies and gentlemen, blackouts. We only heard about those blackouts related to being told the news, being pregnant on January 6th at the clinic, and of the events that occurred once that baby boy was born to her in that bathroom, and until she says she gets back. But interestingly enough, she remembers her dad coming that day, giving her medicine. She remembers going to dinner with her family, going to work. So her blackouts are kind of selective. And I submit to you, a little too convenient. Because, ladies and gentlemen, there's no question of what you saw happen on that video. Alexis Avila committed child abuse, great bodily harm to this baby boy. And she attempted to commit first-degree murder. Thank you.
Ms. Albuquerque?
Yes, Your Honor.
come January 7th of 2022, as the state rightfully said, and we can all agree, April Nottle, Hector Hassel, Michael Green went to that dumpster. They dug. And as they dug, they found baby boy. And for that simple action, I bet we can all agree we'll all be eternally grateful. But no matter how deep that you dig into the state's case, no matter how hard we look at all the evidence and how closely we look at it, as long as we pay close attention and we review everything that we have seen, you, ladies and gentlemen of the jury, after looking through it all, what you will not find beyond the reasonable doubt is that Alexis did commit a crime of child abuse resulting in great bodily harm. And what you will not find is willful deliberation in an attempt to kill her baby. On that day, Alexis was at home, alone, in this home where she had lived all her life with her family, her mother, her father, grew up with her 2 siblings, her nieces and her nephews who come around, frequent family gatherings at this home. She's at that home where they come together a couple days a week, weekends, eat together. But on that day, something will change in this family, and certainly for the baby boy. Prior to the 7th, we all know that on December 22nd, just a year before, Alexis turned 18. Around this time, Alexis was a senior in high school. In her earlier years in high school, she played softball, and she had to stop playing because she was in a car accident. Caused a back injury, and she was not able to be cleared to play. Back injury that has caused her pain, frequent pain, since that time. At that time, she was a senior, getting ready to go to college. She had put out applications to go to certain schools. Her personal favorite, McMurray Christian University, where she intended to study to be a psychologist or maybe a teacher. And come January 4th, just after the holiday weekend, come January 4th, Alexis has pain. She recognized this pain as lower back pain that she has had frequently since that accident. That's what it felt like. She tells her mother. Her mother takes her to the hospital on the 4th of January. On the 4th of January, she gets there. She told the doctor what was wrong, and she told you. The doctor stood back, observed her, diagnosed her with lumbar sprain, and prescribed medicines to her. Naproxen and Tylenol with codeine, an opiate. Alexis, still in pain, leaves the hospital. She goes home. She takes her medicine that had been prescribed to her to help with back pain. The pain does not stop. She attempts to continue to live her life, but it does not stop. She now goes back to the clinic on January 6th. Thursday, January 6th, she goes back to the clinic. She sees a different doctor. Her pediatrician's not available that day. And at this time, she tells the doctor the same complaints. Doctor, my back hurts. I'm feeling pain. This is the second time she's seen a medical professional within a week leading to the birth of her baby. And the first time, the doctors missed it. The doctor did not know she was pregnant. The medical professional. Her mother was there. Her mother did not know she was pregnant. She has children. On the 6th, however, the doctor comes up close to her. And as she told you, the doctor touched her knee She remembers that because she does not like being touched, she told you on the stand. The doctor touched her knee and tenderly told her that she was pregnant. 18 years old, getting ready to go to college. Graduation's coming right up. She's a high school senior. She gets this news. And she responds the only way that she knows how to cope with difficult news, difficult situation. As she told you, she blacks out. The only other thing she remembers was being told not to take the opiates anymore. She told you that. Well, she leaves the hospital with everything that she was given, which we find out later, because during Detective Perez's and his team's search, they find the documentation that Alexis had from the hospital. They subsequently find medical records that the hospital kept, but they also find what she had. That day ends and tomorrow comes really fast, the 7th of January. She stays at home. She's still in pain. She now thinks she's constipated. No, she hadn't told her mother that yesterday the doctor said she was pregnant. No, she hadn't told her father or her friends or anybody else. This happened yesterday on the 6th. And her response? In fear, in shock, in confusion, blacks it out, the whole event. But her pain continues. So comes the 7th, January 7th, she's at home. Her father comes home at some point during the day. He gives her some medication to help with the constipation. She stays at home, and that afternoon, as dismissively as the state wants to put it, she has a baby at home. But no, here's what happens that afternoon. Alexis at home in her house, by herself, with no mother, no father, no sisters, aunties, grandmother, no doctor, no nurse, nobody there but her in her bathroom, thinking she's about to have a bowel movement. But instead of a bowel movement, something else comes out. She's 18 years old, never had a baby in her life, experiencing this all alone. Nobody to say to her, it's okay. This is your baby. You're going to be fine. You can do this. Nobody to pick up that baby and clean him up, wrap him up, swaddle him, and hand him over to her lovingly. There was nobody there. It was just her. Nobody to help properly cut the umbilical cord and clamp it. Nobody. She panics. She doesn't panic and leave him alone. She panics. She wrapped him up in a towel. Everything else she does after that, we all see. She places him in a bag. She doesn't know if he's dead or alive. She doesn't know if it's a boy or a girl. The next thing she remembers is being confronted by her mother in the car on her way back from the police. And what is her response? That's not me. I wouldn't do that. That's not me. So, the state brings this case to us, fairly and rightfully so. And we see evidence, we hear witnesses, we've heard it all, we've seen videos, we've seen it all at this point. And here's what we have. April, Michael, and Hector find the baby. One of them get the bag out of the dumpster, puts it to the floor. They're a little freaked out, they're shocked. They just saw a baby in a dumpster, in a bag. April reacts quickly, snatches up the baby, holds him, tries to warm him up. In that moment, those three are surprised. They're shocked. They found the baby. Officer Maxwell arrives. She goes and gets the baby from April. Officer Maxwell, guess what? She doesn't remember hearing the baby cry. We watched the video. We heard the baby cry. Why doesn't she remember hearing the baby cry? Shock, surprise. It's a lot going on. She doesn't remember. She took the baby. She hands the baby over to the EMS technician. He takes the baby, puts him in the ambulance, takes care of the baby. He tells us that within 5 to 8 minutes, the baby had improved. Yes, he needed further medical attention, and he certainly needed a guardian. There's no parent, and what do we do when there's no parent? We take the baby to the hospital. He takes the baby to the hospital. Officer Biddick was there. Officer Biddick saw baby boy. Officer Biddick, again, shocking, confusing, a lot going on. There's a baby in a dumpster. Officer Biddick does not remember that the baby was wrapped in a towel. I see a recurring theme here. We see the baby. He's in a bag, he's in a dumpster. This is not normal. This is shocking. We're forgetting things. What happened with Alexis was more than just seeing a baby. She birthed the baby out of nowhere. Surprisingly, she had birthed the baby. Yes, she responds in shock. She responds in confusion. She responds in a panic. And here we are today. CSD Rebecca Morley testified. She had gone to the house. She had searched, taken photos at least. She took photos of sanitary napkins that weren't hidden, they were bloodied, in the toilet, right there, in the trash can by the toilet, right there in the bathroom. This was the day after Alexis went to police and talked at length with Detective Perez. This was the next day. It was all there in the house. What else was in the house? Bloody clothes, bloody towel in her bedroom. What did she not do? She didn't throw them away. She didn't hide them from the police. They were all right there when the police arrived, when CSD Morley arrived and took pictures. All right there. And then the doctors worked hard. They took great care of baby boy. And they told us a few things. Dr. Kumar told us that he was not septic. He said he discharged the baby. He was the last doctor. He discharged the baby. The baby did not need a specialist. The baby was fine. He had to go to a pediatrician, like every baby does, and will need continued care, like every baby will. But he was fine. Dr. Drennan said the baby, yes, he had been abandoned, but on the 8th, Dr. Drennan said his vital signs were normal at her first evaluation. Had there been some intervention before that? Absolutely. But this was the very next day. Dr. Bowman tells us, and before Dr. Bowman, Dr. Coomer did tell us, newborns cannot function without support. And we're not expecting them to walk and talk and dance or anything, but they can barely even breathe without support. And sometimes they need to be helped out. They can't feed, they need to be helped out. That's normal, regardless of the conditions of birth. That happens. There was a lot of talk about sepsis, and Dr. Nino, the state's child abuse expert, testified and said sepsis is possible even in babies born in a hospital. She also said there was no sepsis in this baby, and the other doctors agreed. Were there other things? Yes. But the baby, within 24 hours, according to Dr. Bowman, in less than 24 hours, the baby was stable. And 5 days of recovery, he said that is ideal. And not in a bunch of babies that were found in dumpsters, in most babies, 5 days of recovery is ideal. And baby boy recovered in 5 days. He was discharged by the 6th day. What else did Dr. Bowman tell us? He said, no, don't want to give opiates to pregnant women. It is not ideal to give opiates to a pregnant person. Why would a doctor prescribe opiates to Alexis? You saw the prescription. You saw the doctor's notes. Why would they prescribe opiates to her? And she was so pregnant, she was about to have a baby in a few days. Why would they do that? And what impact did that have on her? What impact did that have on the baby? What impact did that have on the baby's tone? His responses to stimuli. What impact did that have on him? And then after the medical personnel and the expert, Dr. Ninow, who by the way tells us, again, that sepsis can be from anywhere. Dr. Ninow, who also did not examine the baby, said the baby could have bled out of the umbilical cord. We all know umbilical cords are typically clamped when a baby is born. They are cut properly and they are clamped. We all know this baby's umbilical cord was not cut properly. Officer Maxwell. Officer Maxwell saw the umbilical cord. She was very clear about seeing the umbilical cord and how it was roughly cut. She was very clear about that. She was also very clear that the baby was not bleeding. She remembered that. The baby was not bleeding. Dr. Ninow never saw the baby. Dr. Ninow reviewed reports from everybody else. Nobody said the baby was bleeding. And unless that baby's cord was so far he was bleeding out of that dumpster, any bleeding would have been seen. There was a bag, right? We would have seen it. That baby did not bleed out of his umbilical cord. You know what else that we learned? We also learned that a baby can be anemic just by being born because of a placenta detachment. The baby could very well have been anemic just from being born. Now, after all the medical personnel had testified, the state presented to us the testimony of Detective Perez. Detective Perez started out his testimony and he wanted to tell us so badly that Alexis was lying, and he just wanted us to believe that. But we quickly found out that the first information that Detective Perez had did not even have a source. Who said she was pregnant in March? Who said she knew she was pregnant in March? We know the baby was born in January of 2022. So how was she pregnant 10 months ago in March? Inaccurate information, high school rumors. That's the information that Detective Perez had before interviewing Alexis. He saw the baby, he'd seen the video, But did she know? Was there intent? Was there deliberation? He did not know that. When she appeared in front of him at the police department, he read her rights, number one being the right to remain silent. She did not remain silent. She talked. She said, ask me questions. I can answer them, but I'll have a hard time explaining things. And he asked questions, and she answered his questions. And one thing that she repeatedly said during that interview, she was scared, she was shocked, she was confused. And she repeatedly asked for her mom in that interview. She repeatedly asked for her mother at that time. She said, I'm only 18, I was scared. She said that over and over. And then she asked, is the baby okay? If the baby's okay, I want the baby. Well, Detective Perez doesn't stop there. He tells us he got search warrants. Detective Perez got search warrants for medical records, for cell phones, for the house, for the car, for the ring camera at the house. And he got the medical records, and we saw the medical records. And we saw the part that said that she had a positive pregnancy test that was dated January 6th. You know what he did not see? Any other pregnancy tests from earlier before that. Were there hospital visits before January 6th? We all know that there was one, at least, on January 4th, where the doctor, a medical personnel at a hospital, could not tell that 18-year-old Alexis was 9 months pregnant, or at least close to 9 months, because they said she was full term, right? The doctor missed it on January 4th. And there had been other times prior to January 4th that she'd seen a doctor. Detective Perez will know. And I submit to you that if there was any other medical record that said Alexis was pregnant prior to January 6th, he would have it and he would show it to you. Because the state wants you to believe that she just thought about this 9 months and planned this birth in this perfect condition where nobody will be there, and she will just birth her baby by herself in the bathroom only to just pack it up and throw it away. That she had all this time to think about this and deliberate on it, and this was her plan? Babies don't always come exactly as planned. How perfectly could you orchestrate the birth of a baby in a bathroom alone at home? Whether you had 9 months to plan it, whether it was August, whether it was yesterday. He also had search warrant for her phone. And we know he got her phone records. He got the phone records of a high school senior. A high school senior. Most of us live our lives on our phones. We have text messages about any and everything. We have photos of any and everything that matters. We Google search everything that we don't know, which is a lot sometimes. Intimate details of our personal lives are on our cell phones. And the state, they got everything off of Alexis' cell phone. And all they had to show you that says she knew she's pregnant was this conversation. This communication communication between herself and somebody who nobody followed up to check on and figure out who this person is or why this conversation is happening, and the state gave you this. And at the end of this conversation, at the end of the conversation, in the only conversation in all of Alexis's cell phone, that's what the state presented to you. She says, "No, I'm not pregnant. Hell no." The state attempted to read this conversation to you yesterday and make it seem like there was an admission in the middle of this. There was no admission. There was questioning. There was discussion about rumors floating around at school about her being pregnant, which she denies. How, ladies and gentlemen, how? How can one say that the action was willful and deliberate in coming up with a plan of the time, the date, the location of the birth of this child? This was not surgical. She was not in a hospital. She hadn't planned a C-section. She was trying to go to the bathroom. How willful and how deliberate can she be to attempt to do that by herself? How willful and how deliberate could she have been to then put the baby in a bag that contained her own name and information in the same bag? How deliberate could she have been to not even tie up the bag, to have put a hair tie on it that was broken if she was trying to prevent this baby from breathing? How deliberate could she have been to have driven her car to the dumpster that was directly under cameras, directly under security cameras? That is not willfulness. There is no deliberation. None of it makes sense. It makes absolutely no sense. And Dr. Cave explained to us exactly the issues that contributed to not just this action, but everything that we've seen of Alexis so far. She sat here in front of you all for the last 4 days. She sat up there and she testified in front of you. You watched her testimony, her interaction with Detective Perez, and you heard Dr. Cave describe to you what was going on with Alexis. Dr. Cave, a forensic psychologist and a clinical psychologist. She told us, she said, Alexis was in denial. She dissociated. She told us that Alexis detaches from her feelings, a characteristic that, according to the doctor, she shares with her mother. She said Alexis has bipolar disorder. She also said that she is moderately impaired for attention. And makes sense that she missed changes in her body. Makes sense that she missed important things in her life. She said she had no ability for abstract thinking, and Dr. Cave described to us what that means. Pretty much applying simple things and making them make sense. instead of just knowing the factual things, understanding the implications of them. She told us that she could even lose focus on or concentration on the things that are important, that matter to her. That's what the doctor told us. And then Alexis gets on the stand and she testified. And you saw her and you heard her. And as she sat there, she explained that in her words, she blacks out. In her words, when she heard that she was pregnant, her reaction was black out. Don't hear it anymore. I don't want this. I don't want to hear this. I'm confused. I don't want to hear it. So she doesn't hear the rest of what she's told. The next day, the baby comes out. Shock. Confusion. That is her reaction. Panic. And as she testified in court, she was detached from her feelings, and you could see that yourself under the watchful eyes of this entire courtroom. And you all, knowing fully well that her fate lies in your hands. She's so dissociated, so detached, so much so that the videos of what happened, the videos that you all see, that is how she remembers the events of that day. Her interaction with Detective Perez, it is the videos that remind her that, yes, that happened. Not her own personal mind, not her own personal memories of that day. She told us that she's been in treatment since then. She told you her story, ladies and gentlemen, as best as she could, considering who she is, that you have learned. At the conclusion of trial, close to the end of cases being presented, the state then brought us Stephen Astorga. Stephen, the father of baby boy. He told us two things. One, very important good news, and the other, not completely accurate. And by his own admission, he had previously testified and said he did not know she was pregnant. And now all of a sudden, he was sure she was pregnant and he knew it from April. What do we know of April? She must have conceived in April and she had a baby in January. So he comes here and he says, yes, in April was when he knew and she knew. And if she conceived in April, how fast was that? Boom. Now I know. But no, what she told you is she did a TikTok trend pregnancy test in August. 2 tests. 1 positive, 1 negative. She's 18-year-old. She was not, actually at the time she was 17. 17-year-old high school senior. She was not waiting to have a baby. She wasn't looking out to get pregnant because that was the next thing to do in life. She saw positive, negative, believed what she wanted to believe, and moved on with her life. And she lived her life from that point until January with nobody knowing, with her not knowing, paying attention, being conscious, being aware of her pregnancy. She lived her life, made plans for her future, moved on until the sudden events of January 7th. The father also tells us that the baby's doing fine. He has a heart murmur, very common condition, and he has asthma. But who else has asthma? His father, Stephen himself, has asthma. But other than this, there is nothing wrong with baby boy. And we're all thankful for that. I told you earlier that after digging through the mess that we've seen in this case, you will not find the charges the state have brought forward. After digging through Alexis' bipolar disorder, after digging through her attention deficit issues, and the opiates prescription she was given by a medical professional, her denial, her dissociation, the way that she copes with difficult situations. After you dig through all of that, you will have options, as the state has reviewed with you at length, of what you can find her guilty of. I submit to you that you may be able to dig through and find enough evidence to say that there was a child abuse, but not grave bodily harm. You may even look closely at the case and you may be able to find attempted second-degree murder, but no willfulness and no deliberation. But I have to remind you that the burden in this case is solely and completely on the state to prove to you beyond reasonable doubt whatever it is that you choose your verdict to be today. It is solely and completely on the state. We did not have to present evidence in this case. We're not obligated to, but we did. And Alexis put herself out there, flaws and all, for you to see, listen to, and ask questions, and you did. And so that burden being on the state, fully and solely and completely, if you then look through the case and then you decide that they have not met their burden, then you do have the option of finding her not guilty. Ladies and gentlemen, I am going to take my seat now, and I will not get to speak with you any longer on this case. And I just want to take this moment to extend Alexis' gratitude for y'all's time and attention to this matter. On behalf of herself and my team, we thank you.
Mr. Lewis?
You guys still in the room?
and gentlemen, there is another jury instruction that should have been read to you concerning willful and deliberate intention and what it means. A deliberate intention refers to the state of mind of the defendant. A deliberate intention may be inferred from all of the facts and circumstances of the killing. The word deliberate means arrived at or determined upon as a result of careful thought and the weighing of the consideration for and against the proposed course of action. A calculated judgment and decision may be arrived at in a short period of time. A mere unconsidered and rash impulse, even though it includes an intent to kill, is not a deliberate intention to kill. To constitute a deliberate killing, the slayer must weigh and consider the question of killing and its reasons for and against such a choice. The state may reply.
Thank you. Everybody's fault but Alexis Nicole Avila. That's what we heard from the defense. Well, must be the doctor's fault. They're the ones that didn't find she was pregnant sooner and they prescribed. Must be, how her conditions and, bipolar and attention deficit. And she can't be responsible for her own actions and sitting there at her house and knowing she was in pain and knowing the babies came out of her and that she has a phone and that she can't call somebody for help. She could clean up. She couldn't call somebody for help, but she could put the baby in a bag. She couldn't call somebody for help, but she could get in her car and drive around. She couldn't call somebody for help, but she could get out of the car after tying the bag closed and tossing it into the dumpster. Couldn't be Alexis Nicole. He is fault. Well, what do we know about what she did think? She did have to think about picking that baby up and putting that baby in the bag. She did have to reflect and think about carrying that bag and putting that baby in the back of her car. She did have to think about taking that bag and putting it inside another bag. She did have to think about tying it up. And she did have to think about where to go to those dumpsters. And then whether to stop. And then to toss it. And then to get in her car and drive away. That's the deliberate and willful intention and the time to reflect and think about what she was doing. Because when she closed that plastic bag up with that newborn infant inside, she knew what was going to happen. You heard Detective Perez ask her on the video in the interview. So what do you think was going to happen? What was her answer? Well, I knew. And she commented, well, I knew. But I didn't know. No, she knew. She didn't want to think about what she had done. And why would the doctor on the 4th not know she was pregnant? Because when they went in, all they did was just look at her and take her at her word. I'm having that same pain I've had before, and it's worse. Okay. So we'll give you pain medicine. We know you have this condition. She knew she was pregnant. She had taken a pregnancy test before in August. She had taken a pregnancy test in April. Stephen Astorga has nothing to gain by telling you that he knew it in April. Nothing to gain. He came in here and told you. He admitted he didn't say it before, but he said it for you. He knew in April because she showed him the test. She didn't tell the doctor she was pregnant. She didn't tell the doctor on the 6th she was pregnant. Different person saw her. You'll see the doctor's records. It's a female nurse practitioner that sees her on the 6th, and she's like, no, you go pee in the cup. And then, oh, you're pregnant. Defense wants you to think that the state has not proven the attempt to commit first degree because she didn't think about giving birth alone at the house. That's not the crime charged. The crime charged is the intent of taking the life. Once the baby was born and out on the floor in a towel and placed in a bag to asphyxiate, as we heard from one of the doctors. As his blood pressure, breathing, heart rate, kidneys, everything slowly were shutting down. Was it Dr. Honig that said that it was like a drain? A person is just going down, down, down. That baby was deteriorating over those 6 hours in that dumpster. All due to the actions of Alexis Avila. Defense wants you to believe the state hasn't proven the elements for great bodily harm. Well, last I checked, neither myself nor defense counsel were the medical experts in this case. Our argument's not testimony, so for them to say baby didn't bleed out of that umbilical cord, even the doctors couldn't tell you that. They said it would have happened because blood goes in and blood goes out and it's not clamped. So if something comes in and out of that and it's not closed, in their expert opinion, blood came out. So that baby left in that bag had kidney damage, had low heart rate, low breathing, had no fluids for over 6 hours. We don't know what time she had that baby. We just know what time the cameras rig out there show she's at the dumpster. So how long was the baby in the towel on the floor in the bathroom? You don't get to speculate. You don't get to have conjecture. You don't get to have sympathy. That's one of your instructions. You go from what you know. We know that she's on that video a little after 2 p.m. at that car tossing that baby in the dumpster. That's your timeline that we can establish. From then, we know the next time when the Good Samaritans are there after 7 p.m. in the evening. And then we know from there from all the EMS, the police, the doctors. But we don't know how long that baby was on that bathroom floor while she cleaned up. But what we do know is that it's really convenient that Alexis Avila only blacks out what she's told on the 6th with the nurse. It's really convenient that she only blacks out what happened to her after she had that baby. And even more convenient that she couldn't remember the interview that you all saw on the video with Detective Perez, that she blacked that out. How many times did she say, well, it's shown on the video, it's on the video. How many times did she say that? Really convenient. But you know what? Their own defense expert, Dr. Cave, for all that she opined to you, nothing about blackouts. Isn't that interesting? It's not only interesting, it is straight out evidence you get to consider that their own expert didn't hear about these blackouts, didn't hear about how she couldn't remember these things. Blackouts were never used by Dr. K. Ladies and gentlemen, you get to determine the credibility. And I submit to you that once she was caught for the crime, once everybody knew from that video that baby boy had been found, these blackouts became her convenience story. I ask you to return verdicts of guilty. Thank you.
Ladies and gentlemen, I will now ask you to retire to the jury room to begin your deliberations. You will be provided a copy of the jury instructions, and the exhibits introduced as evidence will be made available to you. Prior Prior to beginning your deliberations, you will need to select one of you to act as foreperson. That person will preside over your deliberations and will speak for the jury here in court. Forms of verdict have been prepared for your use. You will take these forms to the jury room. When you have reached a unanimous agreement as to your verdict, the foreperson will sign the forms which express your verdict. You will then return all forms of verdict, these instructions, and any exhibits to the courtroom. Gilberto Ibarra and Kimberly Davidson, you are the alternate jurors in this case, and therefore will need to remain in the courtroom. I'm sure they'll ask you about providing you with lunch when you get in there, because it's now afternoon. Speaking to those members of the jury. Please stand for the jury. Mr. Guillen and Ms. Davidson, thank you for your jury service. We always have alternates in the event something happens to a juror, someone gets sick or an emergency. You are now free to discuss the case. You may not want to discuss the case. If you tell someone you don't want to talk about the case, that should be the end of it. If they persist and trying to get you to talk about the case and you don't want to, you let me know. Because once you tell them no, that's it. If you want to talk about it, you can, but you don't have to. The court and the parties thank you for your jury service, and you are excused at this time. You can leave the interpretive equipment there on the security. The interpreters are also excused at this time, as that was the only juror that might require your services. Thank you, gentlemen.
Thank you, Your Honor.
For the attorneys, make sure you leave your cell phone numbers with Ms. Rodriguez so that we can get a hold of you if we have a question from the jury or the jury returns the verdict.
Yes, sir.
Anything from the state you need to put on the record before we recess?
No.
Anything from the defendant that we need to put on record before we recess? All right, it's now 12:34, court's in recess.